And we are recording. Go ahead.
All right, very good. This is the City of Green Bay Ethics Board meeting for Tuesday, 1st, 2020. Is someone taking roll call, or do we have that on Civic Clerk? It looks like, from what I can tell, we have a quorum.
Chair Van Kessel, you will just need to take the roll call yourself real quick.
All right. So myself, I am here. Alder Galvin is present, correct?
Yes.
Ms. Bakovic, are you present? Ms. Graham? Cheryl, you're present because I can see you.
I am present.
And Ms. Weincheck is present as well. I see his.
Yep.
So we have, looks like we have a quorum. All right. So we'll move on to item number C, approval of the agenda. Is there a motion to approve the agenda for Tuesday, September 1st, 2020 Ethics Board meeting?
Motion to approve.
Second.
We have a motion and a second. Any additions to that agenda or corrections or modifications? I know, Alder Galvin, you raised an issue of the amended agenda, and we'll address that coming up here shortly. But otherwise, if there's no additions or corrections, all in favor signify by saying aye to approve.
Aye.
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 Opposed? Hearing none, the agenda is approved. Then moving on to approval of the minutes from the July 22nd, 2020 Ethics Board meeting. Is there a motion to approve, or are there any additions or corrections? Those minutes were in our packets, so.
Motion to approve.
I will second that. So we have a motion and a second, and again, any additions or corrections? Hearing none, all in favor of approving the minutes from the July 22nd, 2020 meeting by saying aye.
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 Any opposed? Motion carries. All right, so we'll move on to item E, regular business, and we'll call the matter of the complaint filed by Mr. Knight against Alder John Vanderleest. Sometime earlier this year, Mr. Knight, as you know, filed a complaint against Alder Vanderleest. That date on that complaint, because the copy I have does not appear to be dated, but in any event, the complaint was filed. It was reviewed and found sufficient by the city clerk's office under the city's code of conduct for elected officials, and forwarded to this board for review and related proceedings. The matter first came before the board, as was noted just a few minutes ago, at its July 22nd, 2020 meeting. And as it happened just prior to that July 22nd meeting, there were a number of documents filed related to these proceedings. Those documents raised some novel issues, novel at least for this board anyway. So at that meeting, those issues were law department for review and guidance to the board. And as a consequence, in discussion that night with the parties, this matter was adjourned to tonight's meeting, and it was scheduled at that time to move forward with the hearing on this. Since that last meeting in July, though, a number of additional documents and filings have come in from the parties, some as recent as this afternoon. Those recent filings have raised some additional issues, as well as some additional concerns. And for that reason, in discussions yesterday, this matter was rescheduled late yesterday afternoon with an amended agenda for having this as another scheduling conference. And that's where we are this evening. And what I would like to do, unless there's any questions about the procedures to this, is to turn this over to City Attorney Chavez to address those issues that have come before the board related to these proceedings. Any objection to that?
No.
So Vanessa, I would turn this over to you to sort of bring us up to speed as to where we got to where we are tonight.
Thank you, Mr. Chair. So as you guys are aware, our office is actually engaged Attorney County at this point in order to represent the ethics board. A couple of the documents that we received in this proceeding implicate the law department as potentially a responsible party. And as a result, our department felt that we were conflicted out. That said, our office had provided a number of opinions on the issue beforehand, which you guys were, you should have received as attorney-client privileged information ahead of time. So our department has provided legal advice only on procedural matters at this point. And now that we are entering the phase regarding the merits, our office will no longer be providing those, providing guidance to this board in regards to this matter. Instead, Attorney County will be the person who's handling that exclusively from here on out. There are a number of issues that were raised, like I said, that do create some issues for the law department. So one of them alleges that the law department is potentially responsible for training issues. There were some statements, affidavit type statements made. And then we've also reached out to our insurer based on the allegations of First Amendment rights being implicated. So that is the extent of the law department's involvement at this point. We will keep you appraised if there's any developments with regards to the proceedings with respect to our insurers and their concerns about First Amendment allegations being raised in this forum. But my understanding is that everything will be handled with respect to this board's jurisdiction exclusively. And so we are basically taking a hands-off approach at this point. So I will turn it back over to Chair Vandercastle and Attorney County to take you guys from there.
Can I ask a question, Vanessa, or Attorney Chavez?
Yes, sir.
Was it the one or two letters in particular that made a statement basically that because they received no training about social media use as alders, that they were unaware of these laws and statutes and all this other stuff that's being listed here?
Correct.
And because of that, no one's actually making a claim that the city did this on purpose or anything other than the fact that the city, I guess, is it the law department that's taking the stance that there could possibly be a claim in the future or an allegation that they didn't do their job and that's why we're taking this stance?
Not exactly. So we have always treated the complaint that was received in this matter as a notice of injury because it does state the potential for litigation. So that's kind of separate from our determination of this to step back and based on a conflict. Instead, because one party is basically stating that there are failures on the law department's behalf, which resulted in any of the potential violations, we felt it was improper for the law department to then be the persons advising with respect to those matters.
Okay.
All right, any further questions for City Attorney Chavez from the board? All right, hearing none, I would then turn this over to Attorney County, who's been retained by the city to now represent the board in these proceedings. I would note that Mr. County is somewhat familiar with the operations of this board, having represented us on the prior matter. So Attorney County, the floor is yours.
Thank you, Mr. Vandercastle. To introduce myself, my name is Jim Calney. I'm an attorney with Davis and Keelthaw here in Green Bay. My role here is to advise you folks on legal matters and assist you in your duty of collecting evidence in a manner consistent with due process so that you can formulate your report and recommendation. That's basically what I'm here to do. We have to make sure that we afford the accused in this matter notice and an opportunity to be heard. I also note that the complainant in this matter is a layperson. So it's going to be important that we keep that person informed of what the procedures are and what's expected of him as far as allegations are concerned. There's already been some question raised about that. I'm picking up after some process has begun. So what I'd like to do today is kind of catch up. I'd like to go through the process to date. I'll try to do it briefly. I don't want to bore you and take forever to do it. Then I'd like to schedule the matter in the future with your assistance. And as I go through that, I'm sure I'm going to touch on legal issues that have been raised in the July 22nd meeting. So that's basically where I'd like to go today. With regard to documents and proceedings this far, the complaint was filed on or about April 21st. I believe there was an attached list of witnesses from what I can tell with the documents I received. I don't believe there were any other attached documents. And if I'm wrong on that, somebody please so inform me. The summons was issued on July 9 for the hearing on July 22nd. A motion to postpone was filed by Mr. Miller on behalf of Mr. Vanderleest. He also filed a document entitled Argument, I believe contemporaneous with it. I don't know if it was at the same date or not, but certainly before July 22nd. The hearing did commence on July 22nd. It was a Zoom hearing, and as I reviewed the video of this, I noticed that Mr. Miller got disconnected as the hearing was going on. In fact, while Ms. Chavez was explaining some of the process. So I think that led to a little bit of confusion going forward. Basically, what the board did was schedule an August 6th date for submissions by the parties on standing and discovery, and then schedule the matter hearing today. It seems to me, after reviewing the file, that neither party immediately addressed the issue of standing or discovery, at least not within the 2 weeks of August 6th. Mr. Miller, however, did file a document that he entitled Argument. I believe it goes more to substantive issues. And I believe there was a letter from Mr. Vanderleest attached to that document that is close to an answer. It's kind of a response to some of the allegations. On August 13, some documents entitled Citizens Blocked or Deleted by Mr. Vanderleest and a letter from Alderman Wary came to, I believe, the city attorney's office. I believe were also filed with you folks. I'm assuming that the documents entitled Citizens Blocked or Deleted came from Mr. Knight. I see he's giving me a nod to the affirmative. And I assume that the documents from Mr. Wary were either filed on his own or were filed on behalf of Mr. Vanderleest. Mr. Miller, could you?
I filed those.
Oh, you did file that.
Right.
Okay. Okay, I just wanted to get the order.
Yes, okay.
Documents. Okay. There's several undated documents. I'd kind of like to get some feel for who filed them. There's a Wisconsin's ethics, a bunch of documents regarding the Wisconsin Ethics Commission, a request.
Those were filed by me. I also filed documents with regard to a map of the federal district courts, and also from something from Georgetown Law Center indicating how it is determined when there's a binding precedent. And I would also parenthetically note that my being off the Zoom call probably precipitated some of this misunderstanding. That was one of my first Zoom calls, and it got screwed up. So I apologize for my role there.
Well, and it did seem that way.
Yeah.
That's why I wanted to share it with the board. Now, there's also a document, a copy of 7 U.S. Code 320, Mr. Miller.
That was filed by me.
So those documents are all filed by you, okay. On August 31st, Mr. Miller filed a motion to specify plaintiff's claim. September 1, Mr. Knight filed an argument, a document entitled Argument, and we also have a memo from the city attorney's office on standing, discovery, and subpoena powers that was filed with the board. I'm going to address those issues. As I review all these documents, and before I get into the scheduling issue, I want to address two matters. First of all, you've heard from City Attorney Chavez on the role of the city attorney's office in this matter. I want to make sure we stay focused on this, and I'm concerned after reading the documents that we may be getting into an issue that, frankly, this board's not qualified or authorized to address. And that's whether there was a First Amendment violation of some sort here, or a violation of some of the rules that the city might have outside of the ethics code dealing with the transmission of information over the internet, media related. I want to make it clear that those types of issues, particularly the First Amendment issues, aren't in your pay grade. They're not ethics code violations. The real issue here is whether there was a violation of the ethics code. And I note that well, there he is, okay. Mr. Knight, I like to look at you when I'm talking to you, that Mr. Knight actually cited Section 4 of the ethics code. And that particular provision, let me kind of read it to you. Okay, where did I put it? That particular provision of the ethics code reads as follows. Give me a second to find it. I should have had it handy. Making the public feel welcome is important to the democratic process. No signs of partiality, prejudice, or disrespect should be evident on the part of the individual council members toward an individual participating in a public forum. Now that's First Amendment language, so I can understand why there's some confusion there. Every effort should be made to be fair and impartial in listening to public testimony. Council members are expected to demonstrate both publicly and privately their honesty and integrity, and to be an example of appropriate ethical conduct. All council members should convey to the public their respect and appreciation for the public's participation, input, and opinions. I would advise the board that that's the issue here. Whether the conduct here also violates First Amendment rights, I'm going to advise the board not to make any findings on that. Frankly, I don't think you have the authority to. What the Code of Ethics gives you the authority to do is to investigate and report to the board on violations of our ethics code. And in my estimation, the language I just read you is very different than the standards that would be applicable to a First Amendment claim, or even a claim of a violation of some of the city's social media rules. So with that in mind, I'd like to go forward and talk about the other issues that were outstanding from July 22nd.
Callie, can I jump in a minute?
You betcha.
Bill Van de Kessel. I don't expect necessarily an answer today, but if you have one, it's fine. The quote that you just cited from the ethics code that referenced a public forum, it's under the heading of elected officials' conduct towards the public and a subheading of in public meetings. Does that change this in any respect because it appears to start out that we're talking about something happening in public meetings, but then it ends that sentence with reference to a public forum. And so I think there's some confusion there as to where those two terms mesh together, or maybe they don't mesh together.
Well, normally headings don't have the power of law. So I'm going to start with that premise. But that being said, I'm going to leave that to the parties to argue. If Mr. Miller thinks there's a problem with that provision, I would expect he'd argue it. And I would expect Mr. Knight would explain why he thinks it's applicable. That's one of the things we can do in the motion practice once we've scheduled this properly.
Very good. Thank you.
Sure. Okay, the other issue I want to address is standing, discovery, and subpoenas. I'll get into subpoenas as we do scheduling in more detail. In my opinion, very clearly, I think it's under the state code actually, the ethics board has the authority to issue subpoenas to make people appear before them. I believe are to be issued by the chair of the ethics committee, so, or the president, depending on the title. So what we've done, and we've done this in the past too, is we will set a date for people, a deadline for people to request subpoenas who feel they might need them for the eventual hearing. With regard to standing, there's a provision in the code that says any person who believes an elected official in his or her official capacity has violated a requirement, prohibition, or guidelines set out herein may file a sworn complaint with the clerk. I think it's clearly intended that any citizen who believes they have observed unethical conduct will have access to this body to address and have investigated that conduct. I don't believe there's the normal aggrieved person standard as you would have in civil law. With regard to the discovery, I don't believe we have discovery authority, and more importantly, I don't know how we would enforce it. We do not have contempt powers. If people didn't subpoena, with regard to discovery, we'd be in, I don't know how we'd enforce it. And if there was some irregularity in the discovery, again, I'm not sure what authority we would have to deal with that. Consequently, I don't think there's discovery. That being said, I think it's very important that we encourage the parties to exchange the information they are going to be presenting. Mr. Miller has already raised a concern that he doesn't have specifics with regard to factual allegations at this point. Mr. Knight has said he's got a number of people ready to testify. What we would do is, there's a couple ways that can be handled. First of all, information can be exchanged up front. That's not. If that information is not exchanged up front and evidence is presented and Mr. Miller says, hey, I need some time to prepare, we might be bumping into yet another hearing date. So again, we strongly want to encourage the parties to exchange information prior to the hearing. So given all that, we have a number of things that we're going to want to do before the hearing. We're going to want to set a date, of course. We're going to want to talk about the disclosure of evidence and disclosure of witnesses. We want to give time for procedural motions, or including motions to limit evidence, motions to dismiss, motions to clarify, and give people time to support that with briefs and arguments and to respond to that. That spreads out some time here, but we want to get this right the first time. And I think it's important that we address all. As far as the procedure for issuing subpoenas, I think we want to set a date to give adequate notice for the issuance of subpoenas, and again, talk about the process. That is the need for Mr. Vandecastle to sign them. So I'd like to kind of start walking through that. First of all, to accomplish all that, I think you're looking at least a month to give people a chance to file their motion. First of all, disclose the witnesses, because that's going to have, and talk at least a little bit about what's going to be produced. That's going to have some impact on the motions, and then you're going to need some time for motions and time for response. So I think you're out there a month, maybe a month plus. I would suggest that we look at early October, early to mid-October to schedule the matter for hearing. And of course, have leave if there's some complication that comes up for me to contact this body and ask for further time if necessary on behalf of the parties. Hopefully, I noticed that Mr. Miller very strongly requested having a in-person hearing. In my experience, that is a much better way to do evidentiary hearings. It gives the board an opportunity to judge the credibility of the witness a little bit more, looking at body language, etc. I don't know that by mid-October we'll be able to do it in person, but at least the delay may serve to help us there. Disclosure of witnesses, I was thinking September 11. And what we're talking about is who will testify and any documents supporting what you want to introduce. Okay. And Mr. Knight, if you have any questions about this, please feel free to ask me about that. If there's then after that, procedural and evidentiary motions, I would suggest give the parties a little bit of time with the witness list and with the documentary evidence, assuming there is some more, to look that over before they make their motions. So I would say that the logical time to have the evidentiary motions due by would be September 18. That gives you about a week after the exchange of evidence. And also we're going to ask that there be briefs or some sort of explanation accompanying any motions that are made. And then give a week for response. We're already out to September 25th. And then we need a little time on my end, by we, I mean me, and maybe to some degree Mr. Vandecastle, to determine some of the procedural and, in my case, some of the substantive issues to advise the body. So assuming that I should have at least a week, we're in early October. Again, I would suggest some sort of meeting date in early to mid-October. As far as the procedures for subpoenas issued by Bill, by President Vanderkellen, we would do that upon a written request to Mr. Vanderkellen. We will then create the subpoena. Mr. Vandecastle will sign it, and we would ask that it be filed, I would suggest 10 days prior to the hearing. That way we have plenty of time to get all that done. And then we'll give it back to the parties to serve. That's pretty much the procedural things that I need to talk about. Obviously, the main thing that this board has to establish is when they're going to be able to get together to hear this. And again, I think if we're going to be complete about this, we're looking at mid-October, maybe early October.
All right, anything further, Attorney Cowley?
Nope, that's what I wanted to cover at this point in time. I'll leave it
May
to you.
I be heard?
Schedule it.
But just hang on, Attorney Miller. We'll get you in a minute. Any questions to Attorney Cowley from members of the board? All right. I think what we'll do is just to follow the procedures here is that we'll entertain a motion to open the floor to let Mr. Miller or Mr. Knight address the board and Attorney Cowley at this point. So I will make that motion. Is there a second?
Second.
Right. Any further discussion about opening the floor? Hearing none, all in favor of opening the floor to let the parties address the board and Attorney County, signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Motion carries. Mr. Knight, you're the complaining party here. I'll give you the first opportunity to address the board or Attorney County if you have any questions at this point.
Well, thanks for giving me a second here to kind of process this and go through, you know, this whole process. Obviously, I'm the least qualified legal representative here, and I'm just trying to help a number of people in the district to find some closure. So, my first number of questions would be that the timeline. It sounds like there's going to be some amount of time for Attorney Miller to send over some amount of specific things that he's looking for. Is that correct? Because I've already supplied an itinerary of the involved aggrieved parties. So I don't need to be sending that over, right? So that the first thing we're going to be looking at is what the defense is going to be wanting to ask those witnesses. Is that correct?
Well, I'm going to leave that to Mr. Miller to respond to directly. I think Mr. Miller has already, however, brought before the board his concern that as the document sits now, while there are allegations of violation of the ethics code, they're somewhat conclusory. You say that people were blocked. You don't say when, though. You say that people's conversations were stricken. You don't say what conversations. And I get my impression from what Mr. Miller had said, and just the way these things often go, is eventually he's going to be asking for that. And obviously we're going to need that. That's going to be part of your proof.
Sure.
Okay. So that's the type of thing that you may wish to exchange at this point in time. As I explained before, if for some reason you chose not to disclose that at this point in time, after your case closes, after you've presented your case, if the first time Mr. Miller hears that is at the hearing, it's very likely he's going to request some time to prepare his defense. And the bottom line is that takes us more time.
Right. Okay. So just you know, to kind of cover some of what you just mentioned there, there are a number of allegations that are being made by the aggrieved parties that are listed, right? And there's 5 different parties that are listed. There's like a gray area here with the allegations in that a number of these conversations had occurred, but were not able to be recorded. So although there's not a lot of evidence, it can probably be communicated to the best of their recollection. But the nature of the complaint itself is that these conversations they no longer exist because they were erased. So is there some issue with not being able to provide some verbatim record of those conversations or those comments or posts?
Well, the particularity of that testimony will be weighed by the committee, by the board, excuse me, as they determine the case. If there aren't particulars about dates, but you can approximate, if you can give ideas about what was discussed, what type of thing was deleted, and approximately when is a very important thing. Those are certainly issues that we can weigh.
Well, all right. Well, I think I can definitely supply those things. I already have a decent understanding myself after some decently extensive conversations when formulating this entire this complaint. I have kind of a timeline of years and months, because a number of these conversations correlate directly with different city issues that had occurred at the time. Different conversations were going on regarding, let's say, the wheel tax, for example, or the Colburn Pool restoration, or parking issues. So there are a number of different specific timeline issues
I
that
kind of gathered that from what has been presented.
yeah, right. So, all of the people who I think are going to be able to talk will be able to speak to those issues. I think they recall, I mean, obviously they recall better than I do because it wasn't there, but I think all those people are certainly willing, right? And I can certainly do my best to present those as well, if that's something that you're looking for.
Mr. Knight, anything further?
I don't think so. Will I be able to, Attorney, will I be able to contact you after this hearing? I have contacted with a number of kind of processing questions, the Attorney's office, kind of the ins and outs of the entire process. Will I be able to contact you with further questions in your capacity right now?
You may, and there's a bit of an issue there. It's one thing for me to talk to you about procedural issues. It's another thing for me to actually give you advice on how to do them, other than in Mr. Miller's presence. So whatever communication we have, let's make sure we record it so that Mr. Miller can take a look at it and make sure that what we're doing is above board. But yes, you can ask me questions, and yes, what I'll probably do is share them with Mr. Miller so that we're all on the same page.
Excellent. Thank you very much.
Sure.
Any further questions, Mr. Knight?
I don't have any further questions. No, thank you.
Attorney Miller.
Yes, I got quite a number of points to raise. First of all, I think Mr. Comey's summary was very interesting, but when you change the medium from the internet to a public meeting, that's quite a transmutation. And for example, one of the things that I cited was Section 230 of the Communications Decency Act. And that gives an individual the right to basically manage his or her website, especially when it has objectionable conduct. Part of that.
If I can interfere, Mr. Miller, I don't want to get into issues that you could bring a motion concerning at this point in time. If you think that there's a problem, if you think
there's a problem because the legislation preempts the field, but I'm happy to bring a motion on that.
Yeah,
okay.
That's what I would ask.
Okay, I
address that tonight.
I guess perhaps my editing was insufficient, but I just made some notes here and I'm going through them. With regard to the discovery, I understand Mr. Conley's position, and he raised the problem of how it was going to be enforced. I think the parties can agree on discovery basically on a contractual basis and to be enforced by the board. And if somebody doesn't comply with the discovery, their case is dismissed. This is what would happen in a court, and we can do the same thing. I mean, right now, it's very similar to trial by ambush. I don't know what these people said or wrote, and I don't know what's been preserved. I did make overtures. I wrote letters to all 5 of the prospective witnesses. I talked to a couple of them. One said that he had some stuff preserved and he was going to send. Nothing was forthcoming. My concern here is that this has been morphed into a he said, she said situation, as opposed to when I came in here this evening, I felt it was really a matter of law. What can somebody who's running a website, what is he or she permitted to do? And for that, I cited some cases that were opposed to Mr. Knight. I cited the Wisconsin Ethics Board's guidance, which permits people to manage posts, and it went on and on. So the idea that this is that's where I was going. The idea that this is the same as a public meeting, I would have some problems with that. For issue one, it stays on the website. I mean, if it's an objectionable conduct, and regardless of how one gets into that category, it appears that the sponsor of the website then endorses it. And that's different than some action taken at a public meeting where a person is mistreated. So I think there are substantial differences from your perspective. And I mean, quite honestly, as we came here tonight, I was prepared to address the internet interactions, because that's the way this has always sounded. And I think the other part here is that Mr. Vanderleest or somebody in his position would react to the advice or his knowledge with regard to how to conduct something on a campaign website that he was running. And it clearly says campaign website, which I would submit to you, and I cannot raise this in the motion, different than a public meeting. So there are substantial differences, although I think it's an interesting I think it's an interesting argument, but I don't accept that.
So I don't want to get into. I mean, this is starting to sound to me like a motion hearing, and
No, I'm not arguing anything. I'm just. You asked me my objections. I'm giving you my objections.
No, I was asking if you had any questions to the process that's been outlined by Attorney Calney.
Well, I guess I would like to add one more thing. There's no present intent to sue the city of Green Bay. So I mean, nothing should be inferred from the information that I filed that we're planning on a lawsuit at this point. Although I talked to Mr. Calney and I was concerned about my client's constitutional rights. And Mr. Calney's position is quite positive as far as resuscitating or protecting my client's rights. So I think that issue should be resolved. So I'm in basic agreement with what Mr. Calney is saying. We do need some time, and I guess the questions that I've raised need to be resolved. And I don't have any problems in Mr. Knight contacting Mr. Calney. You can just send me an email, and if it's an email exchange where I'm included, that's fine. Or if he wants to have a conference call, I'm fine with that. And as long as we're talking about procedure. So that's where I'm at. I guess the bottom line is that I see an internet operation as a lot different than a public meeting. And finally, it's going to become a swearing contest, not all that unlike a sexual assault claim. I don't know that at this point, I don't know that any of the evidence has been preserved. So we're going to have Mr. Vanderleest, my client, giving his recollection of what happened in April of 2020. And then we're going to have political partisans on the other side. We have Mr. Knight ran against him. My understanding is that the witnesses were his supporters, which is fine. And they're going to be testified to the contrary. That's a very muddy mix, shall we say. Okay, that's it.
All right, very good. Attorney Calney, one question related to this. We discussed possibly motions by the parties to deal with various issues that are here. Before we actually get to a trial on this, do you have any thoughts on whether there should be a separate meeting of this board to deal with those motions?
It would depend on how detailed they are and how many there are. Normally, what I would say is we could deal with the motions the day of the meeting and go from there. but there is some wisdom to having yet another meeting, to going through those motions. It sounds like there may be some considerable motion practice here.
So my thought then is that we schedule this for a hearing at some point down the road, but with the understanding that that hearing might actually become a motion date, a hearing date, depending on the extent of the motions. Any thoughts?
That certainly makes sense.
Mr. Knight's got his hand up. Mr. Knight, what's your question?
My question is, thanks for calling on me there, it was mentioned earlier that a supplement has been provided to some number of parties here entitled Citizens Blocked or Deleted by Mr. Van der Leest. And in that document, it's a 3-page document, and that was supplied by myself from one of the aggrieved parties listed in the formal complaint. In that document, there are a number of specific examples with screenshots of messages and posts and comments which are now not there. Those are deleted. So I just wanted to ask if everyone has been supplied with that, because there are physical evidences that have been provided to someone here. One of the attorneys must have them. Because it was mentioned earlier on. And in this 3-page document, there are specific examples of people communicating in comments as to the specific issue that they were blocked while they were discussing, the time period in which they were blocked, as well as a number of personal words added by one of the constituents, and a screenshot itself of the specific thing that was deleted. There is nothing injurious or illicit in it, and it's purely an issue about a city tax issue. I just wanted to make, I was just wondering, my question is this: has that been provided to everyone? Because it sounds like it's been questioned whether there is evidence, and I have provided that, and I want for everyone to see that.
I'm quite sure it has been provided to everyone, but I do want to raise a point, Mr. Knight. It isn't evidence yet until it's accepted by this body at a hearing.
Okay, thank you.
So that's one issue. The other issue is it's not real easy to pick that out. Some of what you're saying, I'm sure you would explain it in some detail at a hearing, but
Sure.
that's the type of thing that, Mr. Miller is going to say he should have some notice of. I also want to continue to stress, because people seem to be missing this, this is not a case about the violation of the First Amendment. This is a case about whether there's an ethics code provision that has been violated. So let's try to keep the focus on that. I think those are very, very different burdens. And there's certain rules that apply to ethics code violations too. So all those things I think we need to keep in mind. One thing I forgot to mention is normally when you set a motion schedule, you also set a schedule for when pleadings are going to be closed in case that somebody wanted to amend a pleading. Again, I kind of treat Mr. Van der Leest's letter that was appended to one of the arguments as his response.
All right.
May I be heard?
What's that?
I'm sorry. All right. Anything further on this before we start looking at dates? All right. So Attorney Calney, you
I have a question.
Sure,
I have a question.
Yes, go ahead.
Boy, there's a lot of legalese in the discussion tonight, right? Which makes sense to at least 3 of you. My question is, will there be directions sent to Mr. Knight with regards to what he needs to provide? And Mr. Miller, I mean, is there a way that, I don't know, and I don't want to speak for you, Mr. Knight, but at what point does he turn this in? At what point does he turn this in? I want to make sure that everybody's clear on what happens through that process. So we don't, because I think I see people that might be like, are you bringing your witnesses, for example, to every one of these meetings when maybe you don't need to? Like that kind of stuff. I mean, I don't know if that's proper or not, but I just think as a citizen in Green Bay, if you want to make this complaint and you're not an attorney, I want to make sure that there's at least some kind of a template they can follow.
I don't know that there's a template, but one of the things I'm supposed to do in my role is to advise the parties with regard to what the proper procedure is. Mr. Miller's already said he's okay with communications from Mr. Knight with regard to what the procedure is, so long as he's copied. And I think we can pretty much work through what the issues are together on that basis and minimize how much we have to appear before this body on those issues. With regard to the legal issues in this body, I definitely will do my best to fill you in on at least my recommendations on it before in most meetings.
Thank you.
May I be heard?
Yes, go ahead.
Yeah, I in response to what Mr. Knight said and Ms. Renyer-Wig and my letter this afternoon, I just requested a clear schedule of what's going to happen. I think Mr. Conley is on board with that, and clear deadlines that everybody has to observe. I would submit that it would be far easier to have a special motion night, just so we don't have to have, if people want to bring their witnesses and the motions go for an hour, hour and a half, or they're not resolved. I don't want to waste everybody's time. I would hope that much of it could be done, much argument could be done via writing, but I think it would be helpful to have it resolved before we then embark on a hearing.
Yeah, I would agree. And as far as the scheduling order is concerned, I would suggest that I actually draft an order with all the dates submitted to Mr. Van de Castle to sign, and then we'll transmit it to the parties based on our discussions fixing those dates tonight.
Right. We'll address that in a minute, but let's start looking for some dates for this, and probably starting with a trial date and then moving backwards. I would just reference from my own perspective, I am going to be out of town from October 9th through the 21st. So for about 10 days, right in the heart, in the middle of October, I'm gone. And unfortunately, I don't have the ability to change that at this point. So hopefully we can work around that. So maybe if we're looking at a motion date, that could be before the 9th of October. And then if there's a trial date after that, that would be, or a hearing date after that, that would be later in the month of October.
We have council on the 6th of October, Tuesday the 6th is city council.
Mm-hmm.
But the 7th and 8th, I'm available.
I'm available the 7th and 8th as well.
And so am I.
Yep, same.
All right, so let's look at,
Should just to save time, should we check with Attorney Miller and Mr. Knight and Mr. Kelly also to make sure those 2 dates work for them?
yes, yes. So Attorney,
Just Rob Miller, the 7th and 8th are fine with me.
okay, Mr. Knight?
I'll also be available for both of those dates.
All right. So just in terms of the city, is there anything going on Wednesday or Thursday night, the 7th or the 8th, that might interfere with this? Does anybody know? And there's no committee, are there any committee hearings or other hearings that you would have to attend? I see Alder Dorf with her hand up.
I know on the 8th have that fluoride hearing, the public hearing we scheduled on fluoride, and we've encouraged all alders to attend that hearing. So that's kind of an important night.
Yes, all right. So are you aware of anything on the 7th?
I don't see anything on my calendar for the 7th.
Okay. So can I suggest that we use the 7th, Wednesday the 7th?
As the motion?
Yes.
I'll second that.
All right. So we'll use the 7th as our motion date. Attorney Cowley had referenced some previous dates for submitting briefs and those sorts of things. Attorney Cowley, you want to run through that list again?
Sure, I can run through that list. Before we do that, I think it might be wise to schedule a hearing date too right now, a tentative hearing date, as long as we're all together.
Yes. Again, I am gone until I will be back either on the 21st, but for sure on the 22nd.
Well, yeah, Bill, if you're coming back on the 21st, you never know what might happen. I would say the 22nd is probably, we shouldn't look at that. But
Wow.
going to the last week of October, I'm available 27th, 28th, 29th, Tuesday, Wednesday, Thursday.
Okay.
I am not available the 27th. I am free Monday, Wednesday, Thursday. I'm feeling like Wednesday's a theme.
Yeah.
Yeah.
Attorney Miller and Mr. Knight, any issues with Wednesday, the 28th of October?
I'll be
No,
available.
I'm fine with that.
Mr. Knight, I'm sorry, I didn't hear you.
I'll also be available then.
Okay, very good. So the 28th then will be our trial, a hearing night. All right. So then Attorney Cowley working back from that.
Okay. Yeah, we're going to be, I think we'll be fine with what I actually put together. Disclosure of witnesses, I think we should give a week for the parties to get together and have the disclosure of witnesses and the exchange of documents. And if the parties want, and I have leave of this body, what I might do is get the parties together to discuss the issue, if that's okay with the two parties.
I have no
The
problem.
affirmative from Mr. Miller?
I'm fine with that.
Okay. So we'll set up something before the 11th to get together and kind of exchange information. And I'll get a hold of both of you by email so we can try to find a time for us to meet. We won't waste the body's time with that.
I have a question.
Go ahead.
I assume that when we're scheduling, the start time is always 5 p.m. Is that correct?
Correct. Assuming we can get the recording system. All right. Mr. Cowley, so we've got the 11th. What were the other dates that you had?
And then let's just keep going a week from that. So the 11th, I believe, is a Friday.
Correct.
The 18th would be the time for submitting motions and briefs. If there's a motion to dismiss, if there's a motion to make more certain, that type of thing. If there's an amendment to the complaint, all that stuff in by the 18th. Then responses to that by the 25th. Again, go another week. And then with the issuance of subpoenas 10 days before the hearing date, I'll back that off, whatever that is, that you have to contact in writing, Mr.
My rough math would say that 10 days before the hearing would be the 27th, which is a Sunday. So you might need to use the 25th again as the subpoena date.
Okay. And I think that's all we need to cover as far as scheduling here.
All right.
And if the body's okay with that, let's entertain a motion to set that as a schedule, and then I'll put together an order and get it off.
Before that, we still have the floor open, so we can close the floor just to clean things up, and then you can move on with your motion.
Yes. Yes. So anything further from any of the parties before we close the floor?
I have one other question.
Go ahead.
For the purposes of filing, we're supposed to file the documents with the clerk. Is that the idea?
Yes. Yes, that would be consistent with some verbiage in the, that's where you have to file the complaint and so forth. So that makes sense. That's
Okay,
where you do it.
very good.
All right. Again, one last time, anything further from the parties?
No, thank you.
Nothing. Is there I will make a motion to close the floor. Is there a second?
A second.
We have a motion and a second to close the floor. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Motion carries. The floor is closed. Is there any other issue that we need to discuss regarding this matter? Oh, I'm sorry. We need a motion to authorize Attorney Calney to put together the scheduling order on this, and I will make that motion consistent with the dates and times that we've discussed here over the last half hour or so. Is there a second to that motion?
Second.
We have a second. Any further discussion or questions from the board? Hearing none, all in favor of authorizing Attorney Calney to put together the scheduling order based on these dates and times signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Attorney Calney or Attorney Chavez, anything more on this before we close this part of the proceedings?
I have nothing to add.
Nothing from administration of this, no.
No. All right, very good. So at this point, then this issue is, I believe, hopefully I can say fully addressed for this evening. And we will move forward subject to that scheduling order that we've approved. And we will move on to other items on our agenda this evening. The parties and everybody else who's joined us who doesn't want to stick around for an election of officers, you are free to leave. Otherwise, let's move on then to election of chair and vice chair. As Attorney Mather mentioned, our vice chair is no longer with us, which requires us to elect a new vice chair. And it was my suggestion that we just simply throw in the election of chair as well, since we procedurally have been doing this on an annual basis. And we did not do it at the last meeting this earlier this summer. So that's on the agenda. I guess we'll start with the chair and work backwards. I guess I have no objection to continuing to serve, but if there's anybody out there who has a burning desire to take over the role of chair, please step forward. Raise your hand. Move around.
I'd like to nominate Bill Vandecastle as chair of the ethics.
I'll second that.
I will get you back for this at some point, Cheryl. All right, so there's a motion and a second for myself to continue to serve as the chair. Is there any further nominations? Any further nominations? Any further nominations? All right, I'll kind of skip right to the chase here. And all in favor of the motion signify by saying aye.
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 Any opposed? Motion carries. So I will continue on. Thank you all very much. And now we need to also elect a vice chair. And the floor is open. Is there any nominations for a vice chair?
I'll nominate Cheryl Renner-Wigg.
No.
Aaron?
Die for lack of second. I'd like to nominate Aaron Weinschenk to be vice chair.
I will second that motion.
Aaron, will Aaron accept that?
Aaron, will you agree to be the vice?
Sure.
All right. I will, on that note, I will close the nominations by my own motion, and we'll go to a vote before something else changes here. So all in favor of the motion for Aaron to serve as vice chair, signify by saying aye.
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 Any opposed? Hearing none. Aaron, congratulations. You're now the vice chair. If I don't come back from where I'm going in October.
Oh, please come back.
All right. So we've got that part of our agenda completed. Next is the quasi-judicial hearings presentation training that I believe Attorney Chavez was going to take over on. So Vanessa, the floor is yours.
Thank you. So my internet is not always stable, so I'm going to be sharing my screen and hoping it doesn't freeze, and then I will be talking to you through the phone so that hopefully there's less for the internet to have to do. So let me get the screen sharing started.
And while she's doing that, let me just reiterate what we've talked about is that this is a presentation that Attorney Chavez provided to us maybe 5 or 6 years ago. And in discussion over the last couple of weeks, I am the only one that was around at that time that went through this presentation. So we thought it would be a good time to do this again, just to update everybody on what our responsibilities are in this. So Vanessa, if you're ready to go, the floor is yours.
I just have a question, Attorney Chavez. Will you be sharing this information with the board, or do I need to frantically take notes?
I am more than happy to share this presentation with you all. So
all right. Thank you.
Sit back and enjoy the slideshow. Okay, so everybody can see the screen, correct?
Yes.
Okay, so let's get started. So the first question we always get is what exactly is a quasi-judicial hearing? And the technical answer is it's a hearing that satisfies the requirements of due process of law. And due process is required anytime that we're depriving somebody of essentially their property rights, or if we are affecting a small number of people, which usually happens more in legislation than in what you guys are going to do, or when we're making factual determinations. So that's really the one that applies to the factual determinations about an individual. So this board is constantly tasked with reviewing or hearing, overseeing these complaints, making a determination as to what actually happened, and then once you make those determinations, making recommendations as to what the actual penalty or whatnot should be imposed. And based on the fact that you guys are looking at a set of facts, this is why a due process hearing is required. So when we are conducting a due process hearing, you essentially are you're basically acting as a court in this situation. So if you look at it as there's two parties, they're bringing an issue before you, you're assuming the judge of the role. You're assuming the role of the judge. We impose a number of different standards to ensure that their rights are protected, and to also give you guys some clear direction as to what you should be doing to make sure that you're providing that clear due process. So there are 3 real elements to a due process hearing. They are notice, an opportunity to be heard, and a decision. And those really are the crux of due process at its finest. As long as notice, an opportunity to be heard, and a decision are issued that is not arbitrary and reasonable, due process has been provided. Now, the amount of due process, the amount of procedure that has to go into place changes based on everyone that's coming before you. So if you have something that's really critical, like you are looking at terminating somebody's job, then the amount of due process you have to provide is higher. Where if you are looking at something like, I'm trying to think of something pretty trivial, like a $50 fine, then the amount of due process is going to be a lot less. And so you can tailor what you do to provide due process to each one of those circumstances. So at the staff level, we always take care of the written notice to parties, and we always take care of putting together the hearings so they have the opportunity to be heard. Your real role falls within the decision, not being arbitrary or unreasonable, and then you also have a role in that opportunity to be heard portion of it, because the expectation is that when people come before this board, they're going to be in front of a board that is both unbiased and is also listening to them, not having prejudged the issue. So I kind of already jumped into some of this. So as we discussed, so we take care of the notice at the staff level. What this includes is any necessary instructions. We state the reason for the hearing, and then we notify them they have a right to prepare their defense and be represented by an attorney. In the case that you guys were just discussing, as you'll see, there actually is an attorney representing one party. So that is a right that they are entitled to. And then when we were talking about the opportunity to be heard, the court looks at it from a couple of different standards: meaningful time, meaning soon enough to be useful. So this really applies, like if you look at it in the bigger scheme of things, if you have some case with a ton of witnesses and it's a murder trial, you want to make sure that it's soon enough to where people who have these are going to remember them. You don't want to wait 4 or 5 years to start bringing something forward, because memories fade. And maybe in other contexts, if you have, say, something that's time sensitive, you need to make sure that in that time before their rights are already deprived of, just because of the amount of time that has passed. Meaningful manner, meaning the right to hear evidence against them, refute the evidence, and present their case. So what you guys were just discussing when you were setting forth the scheduling conference is really all that information that you guys are putting forward to make sure that when they are presenting their case, it is in a meaningful manner. The decision is your findings of fact and your conclusions of law. So there are always two components of a decision that is reached by this body. The first, the findings of fact, is literally you making a determination as to the credibility of any of the evidence that's presented to you, and determining what you find to be accurate and truthful. And so you're basically going to establish your record, your decision, as far as what are the facts that everybody, that we as a committee have decided actually apply. And so you'll determine, if we look at like land use cases, you'll look at this property was located in Brown County, it's in the city of Green Bay, it's on this street. So you'll lay out all those different things that you find to be accurate and factual. And then you'll make your determinations as far as credibility as well, like the evidence presented to us was believed to be credible. Those are your findings of fact. So the second is the conclusions of law, and that is where you really rely on the advice of your attorney to provide you with recommendations on what is and is not acceptable. And then you'll also be making independent determinations as to whether the law, as it's been presented to you, applies to the facts that you have concluded. So when you are looking at the information, what you are looking at is the record. And the record is really everything that is to be considered by you all as you are making your determinations on the findings and conclusions. So that means in these instances, it is limited to what is presented by both parties at the hearing. One thing that we stress, and this doesn't usually apply in ethics hearings, but we do stress, is this means there cannot be any independent investigations. Those actually are considered a form of ex-parte communications, and ex-parte communications are also prohibited, meaning that you have a conversation with one person, one party, and not the other one. So that anything that you do outside of the hearing really should be a red flag that you should stop and probably talk to the attorney representing you and determine whether or not it's something you should be engaging in. And then the last component of your decision is it can't be arbitrary or unreasonable. That means, you can take those words as their base level, essentially, like there should be a reason for it, and that it should be based on the facts and the law. Like whatever you guys come up with as your findings of fact and your conclusions of law should really support your decision. If your decision is contrary to everything you've just found, then that should be your little radar going up, like, oh, maybe we should reconsider our findings or our conclusions or the decision we're ultimately reaching. So let's talk a little bit more about ex parte communications. There's really 3 ways to get in trouble when it comes to quasi-judicial hearings. Ex parte communications is one, bias is another, and conflicts of interest is the last one. Ex parte communications is literally anything that is not part of the record that you are considering, any evidence that you are considering. This is not just statements or discussions with one party, it's with witnesses. So if you're talking to a witness and it's not on the record, that's a problem. And if you're discussing issues with members of the community who could potentially be providing input on it, again, that's something that you need to stop and make sure that it is brought into the actual record. You're limiting it to the record. So the reason we don't allow ex parte communications and the courts have stated that they are a problem is a number of different factors. You can see them listed here. You can either be improperly influenced, inaccurately informed is one of the bigger problems. You're only provided one side of the issue, and you're susceptible to influence. But really, the biggest problem is that if you're only hearing evidence from one side from one party, you're not hearing it from the other, so they're not getting an opportunity to actually be heard, to address any concerns or address the issue. So that's why it has to be on the record so that both parties are able to respond at the same time. And if you engage in ex parte communications, it can ultimately invalidate the action that the board has taken. So what happens if you accidentally have an excommunication? Well, you ask yourself a couple questions, and you'll want to consult your attorney who's representing the board. The first is, have you prejudged the matter? And the second is, are you now biased? If you can no longer fairly and impartially participate in the hearing, recusal is necessary. And the reason that is because that opportunity to be heard is literally an opportunity to be heard. And if you are no longer hearing them because you've already made up your mind, then you've taken away that component of due process. But what if you have not prejudged it and you're not biased? Great news. It's not something we can't overcome. It just means that you need to disclose the communication and make it part of the record. So this happens a lot of times where people will get emails from people and they've read them. They don't really know what to do with it. The solution is you notify the parties at the beginning of the hearing and you put it on the record as part of the hearing itself. So generally what will happen at the beginning of one is the chairman will read a script and ask if anybody has any biases and if anybody's received any ex parte communications, and that's your opportunity to say whether or not you've received anything. And it clears it, it really does, because then anything that you talked about is now part of the record, and the other party who wasn't a part of it is able to address it for the rest of the committee. The second issue that will really get you into trouble is conflict of interest. This one doesn't come up as frequently in ethics situations as it does, say, in land use situations. It's more common that somebody will own a piece of property next to a property that is being, I'm sorry, I'm distracted because the screen just froze on my end. It's really odd. But what will happen usually is you will have somebody who has an interest in a piece of land, and then it comes up before, say, the Planning Commission, and the Planning Commission has to make a determination. Oh, I think I just got kicked out. Are you guys still able to see things?
Yes.
Okay. So the Planning Commission will make a determination, and then the...
now Vanessa, it just disappeared.
Okay. Let me see if I can get it back.
We spoke too soon.
I know.
Oh, sorry. Vanessa, you need to be on if you send it to me, I can share my screen.
I don't have Wi-Fi to send it to you.
Oh.
So give me a second because
I'm on it. Hold on one second. I can pull it up. And then Celestine, can you make me a host so I can share mine?
Yep. Okay, you're the co-host now.
Thank you. I just got to find the slide we were on. Just give me 1 second.
Oh, I think I'm back.
Figures.
So it's really weird because all I have to do is shut off my Wi-Fi, like put it in airplane mode, and then it'll want to come back. Okay, can you guys see it again?
Back.
Great. So what we were just saying is that the conflicts of interest occur more frequently in situations like where you have land use, where somebody owns property next to somebody who's coming in for a CUP. A member of the Plan Commission is probably affected by that. They have a direct financial interest or a real interest in their property. And so that's where you see more of those conflicts of interest. Doesn't mean it can't arise, but it's unlikely in these types of situations. But if you ever have a situation where you have a monetary or material benefit, you will need to alert the attorney so that you can walk through that so you can determine whether or not it's something that you will need to recuse yourself from. Not all conflicts of interest require recusal. It's only something that is a direct monetary benefit. And again, whoever's representing the board will be able to assist with that. The other major issue is bias. So recusal is required anytime bias exists, or even if there's an unreasonably high risk of bias. So what that is a more common scenario than conflicts of interest. That happens whenever somebody is advocating on behalf of a party. They make comments prior to the hearing that tend to imply that they've already kind of made a decision, or if they even have a history with a person, then there's some potential bias there. And again, it doesn't necessarily have to be that you are actually biased against somebody. It has to be an impermissibly high risk of bias. So if you have someone that comes before this board and you do have a strong history with this person one way or another, whether it's somebody that you just really work really well with and you can't possibly believe that this person would do something, then that is somebody that you should go talk to the attorney and talk through the extent of your bias and whether it's something that would require recusal. So the other issue is that merely having an opinion does not mean you're biased. You get to have opinions just the same as everybody else. And the important thing is that you can be impartial. As long as you're still able to provide a fair and impartial hearing, you do not need to recuse yourself. And ultimately, it is your determination as to whether or not you can provide that fair and impartial hearing that's going to control. So nobody's going to be able to tell you, I'm sorry, you're biased, you're not able to participate. It's your determination. You're the only one who knows whether or not you can still be fair and impartial. It may be raised as a factor that somebody will need to be considered, but as far as making that determination, it is your determination to make. If your decision gets challenged later, based on it, that is a very high standard for somebody to try to prove that you actually were biased against them, especially once you've stated on the record that you are not biased. And again, if you have any one of these come up, it is important that you disclose it on the record so that you can make it clear that you are still meeting the due process requirements of providing an opportunity to be heard. So at the hearing, again, this is what we were talking about earlier, which is it kind of depends on the level of the deprivation or the penalty to be imposed that affects the actual amount of procedure that's required in it. But there's a general approach to it in all cases, which they have an opportunity to present their claim or defense. You have witnesses who are sworn in so that you are ensuring that any testimony they're providing is basically under penalty of perjury. And then both sides have an opportunity to cross-examine, to examine and cross-examine, and then the chair presides, meaning that, so for example, if somebody disagrees and says, I object, this information should be admitted, the chair overrules it, then they could appeal to the rest of the board, and the board makes a determination as to whether or not they agree to be admitted or it should be excluded. So it does not apply to a decision of the actual outcome. That's not how this works. This is just the procedure and the process that is involved in it. The actual decision is made by the board as a whole, and then so the chair would just be one of those not actually making that decision independently. You can establish time limits. This one is another one that it just kind of depends on how much you feel is necessary. So each party, whatever you determine, they have to be provided equal time. So you could determine that each party needs an hour. You could determine that each party needs 10 minutes. Just kind of depends on how complex the issue is. You can assign limits per speaker. So if you have multiple people showing up to speak, this usually won't occur in your situation. But so, for example, if we are imposing a conditional use permit, or we have a law that only affects like a certain handful of people, a lot of people may show up, and so you're not going to. You could limit it to say 10 minutes for everybody to speak, or you could say 2 minutes per person who's here to speak on X topic. And then the swearing procedure, the chair is the person who swears in all the parties and staff. Here's the basic order of presentation. It does change based on what is happening in each individual case, but generally if you have a staff presentation, you would do that at the beginning. That's your opportunity to hear from, in this case, your attorney, or if there's information being provided to you from staff, then that would be for first. And then you would hear, in this case, would be the claimant, and then the person who, the defendant, essentially. So they present their case, and then you would just keep going in that order. So it would be claimant, defendant, claimant, defendant, and then you have an opportunity to discuss and ask questions. So all of the questions are supposed to be directed through the chair, but that doesn't mean that the board can't actually ask questions. It just means they need to be directed to the chair while you seek the information from the parties. So you are not limited to just the information that they have put onto or that they've presented. Just like a court is able to ask questions of any of the witnesses or any of the parties, you can ask that as well. There's still questions that remain in your mind that you feel are necessary for you to make a decision. Oh, and then of course the last issue is you take your action, meaning that you guys will deliberate and come up with your decision. This is something you guys will be experts on. Rules of evidence don't apply. In order to you can establish different standards as to what the evidence is actually going to be in individual cases based on what the parties agree to. But as far as evidence goes, the only requirement is that it be credible, relevant, and probative. That means it has to be believable, and it has to either prove or disprove something. You don't want to just let them come in and talk about how their doors are brown or their cat is orange when you're talking about whether or not somebody violated an ethics code. So those are the real crux. That's the crux of evidentiary standards. You can consider a witness testimony, exhibits, and site visits, which are incredibly rare. I don't think that there will be any time when you guys will actually need to conduct a site visit. So instead, you're going to limit it to hearing testimony from parties or their witnesses, and then also from any exhibits they may produce, which is likely to be pictures or documents of some sort. You do not always have to do sworn testimony, but you should do it because, again, if they're doing it under oath, then it keeps things clean, and there's you don't have to worry about or it helps you make your credibility determinations if somebody has said they're willing to do that under oath. And then the witness list is part of the record. That's something that's required but that will be handled at the staff level, so you will not need to take care of that. Okay, so this is the types of stuff that could be included as far as exhibits go. And what's important to remember is that everything has to be admitted into the record before it's considered actual evidence. That was brought up by Attorney County at one point earlier this evening, where he told one of the parties that the information that he is discussing has not actually been admitted as evidence, and that is because you guys are not establishing a record yet. You will do that at the hearing. And there's two ways to do it. You guys will ultimately to figure out what's easiest for you. You can admit exhibits at the beginning of the hearing, or you can do them as they're introduced. Sometimes it's easier just to have everything in so people don't forget to do it later. And other times people like to just have them in one at a time. Unless you're the chair, I wouldn't worry too much about that. And then of course we keep an exhibit list as part of the record. Again, that's something staff will do for you. Objections are something that they are allowed to do. They have to be made on the record, and then you give both sides a chance to respond, just like you would expect to hear in court. It will happen occasionally where somebody will object, and we just don't really know yet if they're right or not. And rather than make an improper ruling, you can decide to hold the objection, and then as you are making your determination, you rule on them then. So as you are in your deliberations, if you go back and say, okay, so somebody objected to this information, we weren't sure if it was actually going to be probative or if it was relevant, so we said that we would reserve deciding it, but now we've determined that the cat actually is important to this because the cat is, what was typing on the computer, not the person. So in those instances, you might make a determination that it is probative, and then that's when you make that you just need to make sure that that decision is made as part of the findings and conclusions, or announced as part of the decision. Hearsay, that is a legal standard that you should let your attorney advise you on. So hearsay is defined as any out-of-court statement. There's a second component, but anyways, either way, so if it's not something that's made part of the hearing, like somebody's not actually saying it directly to you, and it's somebody saying, he said, they said, so-and-so said, but that person's not actually there to talk about it, like if they called me as a witness, or they started saying about what I said and they didn't call me as a witness, that's technically hearsay. So in court, it would never be allowed in hearings such as this. You can allow it, that's not a problem. You just need to make sure that you are also using corroborating evidence. Usually means something like, well, of course Vanessa said it, she said it while she was sending me an email, and here's the email that she submitted to, or sent to me. And then when you are ready to take action, you will be able to deliberate in closed session. You will make your decision in open session. So when you go into closed session, what will generally happen is you will talk about things. You will figure out what you all agree are the findings of fact. You'll talk through and figure out what those issues that have been presented to you believe are factual. You'll list those, and then you'll also come up with your conclusions. So based on those facts, you're applying them to the law that's provided, and you're determining whether or not you believe a violation exists or doesn't exist, or whatever conclusion you ultimately reach. When you come back out into open session, that's when you officially make your motion and your second, and you must actually vote by roll call vote. So you can't just do everybody in favor say aye. It has to be a roll call vote with each of you stating your vote separately. And then, okay, so before we finalize that, the one thing that we have done pretty well for you guys lately is we are pretty good about making sure that the conclusions and the findings of fact are all completed while we are in closed session, so that your record is complete and you're not having to remember things as we finalize things later. So I imagine that is something you guys will continue to do. It takes a little bit longer, but it makes it a cleaner process so that everything that you guys discussed gets captured that night. So in summary, as you guys are doing this, remember there are really three main takeaways. For due process, you need to have notice, not your issue, opportunity to be heard, and that means that you're going to be impartial and fair, and that your decision you make is going to match up with your findings and conclusions. And pretty much anytime something comes before you, it's going to be a quasi-judicial hearing. The exception will be if you guys are making recommendations on changes to an ordinance. That will not. Almost everything else is going to qualify as a quasi-judicial hearing. And as long as you guys are able to do this, there will be no issues. So with that, I will see if you guys have any questions.
Any questions for Vanessa? Well, very good. Thank you, Vanessa. It's very insightful and very helpful. So, again, anybody have any questions for Vanessa on any of this? All right. Then it looks like we are ready to move to adjournment. Is there a motion to adjourn?
So move.
Second.
We have a motion and a second. Any further discussion? Hearing none, all in favor signify by saying aye.
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 Very good. We are adjourned. Thank you all very much.